Hey guys, am I audible? Am I visible? Okay, just give me a heads up if you can hear me, if I'm visible, if I'm audible. Hello. Hello, Vishwa. Hello. Hello. So, guys, I hope your studies are going amazing. Okay? I'll just keep this in front of me. Just 1 second. Not audible? I'm not audible, guys. Am I audible? Just let me know if I'm audible or not. Am I audible? Am I audible? Audible? Okay. Audible है? है? Okay. So actually in today's session, I won't waste too much of your time. ये ना दूर जाते ही ऐसा नहीं अभी आ रहा है दूर जाते ही ना थोड़ा आवाज कम क्यों हो जा रहा है okay guys I actually don't want to waste too much of कुछ प्रॉब्लम है आ रहा है जा रहा है आवाज but what I really wanted to do in today's session is that I have just picked up maybe 4 or 5 questions I think I've picked up. But what I want to do here is I want to tell you how you should identify the provisions you should write. So that is the motive of today's session. To waste too much of your time or anything, I just want to show how you are supposed to read the question. समझ में आया? Give us 1 second. There is some audio issues, it seems. So what we really want, I want to do in today's, basically, I want to show you how to read the question, how to identify the question, and how to identify what all provisions have to come to that question so that you don't miss out. Also, when I was reading one of the questions of one, I was reading examiner's comment on one of the answers. So what I observed in his comment, I want to discuss that also with you all. So that I want to tell you. So this is what I actually aim to do in today's lecture. Voice नहीं आ रही है. You cannot hear me, guys. आवाज नहीं आ रही एकदम. Actually, Garvit, the voice is there. आप या तो अपना voice एक बार check करो. Okay, I want everyone's attention here now. So, I've picked up a few questions as I told you. Guys, audible, I think it's audible, yes? So, I want. Sorry, what is my problem? Guys, just give us 1 minute. Okay, now just give me, let me know, guys, is the voice fine now? Abhi, voice is fine or not? Just let me know, huh? Good evening, good evening. Now is it fine? Now is it fine? Voice ka just let me know once, huh? Is it fine? So, okay, it's fine. ठीक है. ठीक है. So, I'm not going to waste too much of your time. I just want you to learn how to identify. ठीक है? Sahil deals in pre-owned cars. Raju sold his accidental car to Sahil by fraud. So, they are telling only fraud. Sahil could not find that the car was accidental. That means Sahil is ignorant. Akshay, a customer, visited the workshop of Sahil with intention to purchase a pre-owned car. Akshay informed Sahil his intention with the condition that the car should be free from any accident. He says to Sahil, I want a car which is free from accident. He says this to Sahil. Now, Sahil was ignorant that this car was accidental. Sahil sold that car to Akshay. Right? Sahil sold that car to Akshay on erroneously face any accident. On erroneously believing that the car did not face any accident. Found afterwards. So basically here, this could be a mistake also, ma'am. This could be misrepresentation also. If the question would have said that Sahil and Akshay both thought that not accidental, then it would have been bilateral mistake. But here they are just saying Sahil sold the car to Akshay on Iran. That means it was only Sahil who thought. Because Akshay told that I want a car which is free from accident. When he sold this car to him, that means he is saying that this car was not accidental. And this statement was made knowingly or unknowingly? Unknowingly. So obviously, this is what? Misrepresentation. Right? Afterwards, Akshay found that the car was actually an accidental case. He sued Sahil to avoid the contract and also for damages for expenses suffered on car. Taking into account the provision state whether Akshay was eligible to avoid the contract and to claim damages. Now, here there are two contracts. One is between Raju and Sahil and another is between Sahil and Akshay. What everyone will do, they will start writing about this. Why? They are only asking you whether Akshay was eligible to avoid the contract and to claim damages from Sahil. They are only asking you about this contract, not about the contract of Raju and Sahil. So why will you talk about Raju and Sahil? You will talk about Sahil and Akshay. So, yes, your answer was right, Garvit. You did not have to delete it. So first, you will write about what is kya? Misrepresentation first. Second, you will write about consequences of क्या misrepresentation. Now, before I start writing this answer, I'm waiting for you to tell me, can he cancel the contract? Can Akshay cancel the contract? And can Akshay claim the damages? You tell me that and then I will write it. And if these videos help you, do leave a like, because when you leave a like, that gives us the motivation that we are in the right path and helping you in the right way. Okay. Now, if you remember, when I was teaching you, and no one will delete the wrong messages. It's okay if it is wrong, it's okay if it is right. When it's good to make mistakes here and not make mistakes in the real exam. Please understand. When it is fraud, what happened? Why are you crying? When it is fraud, the contract is voidable and you can claim damages. Go to the difference of fraud and misrepresentation. The last difference is it's voidable but no damages. You have no right to claim the damages, right or not? Check, keep your notes in front of you. Keep your notes in front of you. Check it. Check it. It's there. It's given there very clearly. You cannot claim damages. So, how will you start writing? As per the provisions of the Indian Contract Act 80. Okay, guys, always remember ICA is not a short form to be used in the exams. You cannot in the exams write ICA. Be careful about that. You cannot in the exams write ICA. Okay? As per the provisions of this misrepresentation means and includes 1. Assertion of the fact which is not true but the other party believes it to be true. Second, breach of duty which without an intention to deceive gains advantage over the other party. Third, causing, however innocently, the party to a contract to make a mistake about the subject matter. This is the definition of misrepresentation, correct? This is what? The definition of misrepresentation. In case of misrepresentation, the contract is voidable. So, the aggrieved party may either cancel the contract or may carry on with the contract. However, the aggrieved party can in no case claim any damages. This is my first paragraph. Done? So, what is the question asking? State whether Akshay was eligible to avoid the contract and to claim the damages. Second paragraph, guys, you have to write. Acha, one thing, on the day before the exam, I'm going to post a video where I'm going to obviously give you how you're supposed to study for the exam. That is 1.5 day strategy. But apart from that, in that video, I'm going to give you some very important pointers of how to approach the exam and what all to do, not to do. Please make sure you watch that video completely and wholly. That's very important for your exams. Therefore, Akshay can cancel the contract. However, he cannot claim the damages. Right? See, writing answer is very easy. Just identify the provision and make sure that you are not making any mistakes about the provisions. And with this, we are done with this answer. Can we go forward? So I want to see that yes from you all before I go forward to the next question. I should get that yes. Everyone should give that yes to me. Chalo, moving forward. Sheena, a classical dancer. Sheena, a classical dancer. She entered into an agreement with Sheetal Vidya Mandir for 60 dance performances. As per the contract, she was supposed to perform every weekend. Every weekend, and she will be paid 10,000 per performance. However, after a month, she was absent without informing. Okay, you were supposed to perform 60 dance performances every weekend, but only after 1 month only she did not come. So guys, here, due to her personal reasons, tell me whether management has a right to terminate the contract and why. If yes, why? If no, why? Tell me. So because this will show you, this will help you identify the provisions. ठीक है? बोलो जल्दी से. Breach of contract. Okay. Okay. Can we talk about time? Time is given and we have not performed within the time. So can I actually place it or base it on time of performance? Yes. Yes. If they decided to continue, can they continue? Yes. And about damages. So basically here a time was given and the contract was not performed within the time. So we have to obviously specify about time of performance, right? So again, as per the provisions of Indian Contract Act 1872, where in a contract the time for performance is mentioned, the time may be of essence or not of essence. Whether the time, so I only have to write about the provisions of time of essence, everything, because if they accept, if they reject, damages, everything, they've asked everything in the question. Whether the time is of essence or not depends upon the terms of the contract or the intention of the parties. I always prefer to write in the next line the next part of the provision, because it gives a clarity to the examiner also. When he is reading, he gets a clarity in your answer. Where time is of essence and parties fail to perform the contract within the time, the aggrieved party may perform the contract becomes voidable. In such a case, see, I am also writing the same thing. What will happen is you will write it in 2 lines. I am writing it, I am explaining in details. When the question is for 6-7 marks, the examiner expects one very, very important thing. When it comes to your answer writing, I am not interested in the facts of the case. That's anyway given in the case. My interest is in the provision and the conclusion. Make sure you pay more emphasis on that. What people do, they pay more emphasis on the second paragraph. Nahi chahiye re baba, nahi chahiye second paragraph. Okay? In such a case, बिल्कुल छोड़ दो, नहीं याद हो रहा तो. If you cannot remember, don't sit and fight for that. कोई rule नहीं है that they will minus your marks. But if you write a wrong section, definitely 1-2 marks minus हो जाएगा. In such a case, the aggrieved party may either cancel the contract or carry on with the contract. If the aggrieved party cancels the contract, he shall also have a right. He shall also have a right to claim damages. On the other hand, if the aggrieved party accepts the contract, he can claim the damages only if it is mentioned. Once the contract is accepted, it is ratified and cannot be cancelled later. So I have covered all the provisions. So see, my provision, it's a 7 marks provision. Obviously, kuch to content hoga. It will go to these much lines. It will go to these much lines, okay? Now coming to our question, please remember, if in your provision also you have to write 1 2 3 4 and my question also has 1 2 3, make sure you don't write the same, because then the examiner will get confused whether you are writing the provision or the conclusion. So first, whether management has a right to terminate. So second paragraph to just 2 3 lines is enough. Therefore, the management of whatever can the management of whatever can, don't write whatever in the exam, okay, can terminate the contract as the contract becomes voidable. If the management informs Sheena about the continuation, can the management still rescind the contract after a month? If the management informs Sheena about the continuance of the contract, they have क्या? Accepted the contract. Once the contract is accepted, it cannot be cancelled. So the management cannot later cancel the contract, right? Third, can they claim damages because of this breach? Can claim damages if the contract is cancelled. Can claim damages if the contract is cancelled. If they accept the contract, they can claim damages only if mentioned. Okay? So we are done with this. Is it clear to all of you? So now the next question, I want you to read and tell me what all provisions will you write in this question. Quickly. Bolo, bolo, bolo. Give me the provisions. I'm waiting. Okay. Finder of the goods lost goods, ठीक है. All or which respective provision. See, we have, I'll not read the whole question, you have already read it. Acha, I'll read this question, we need to read. Okay, along with quasi contract, bailment will also come here, Chaitra. He found on the road, he found a watch value of 1 lakh. He picked up and then advertised in the newspaper. He picked up and then advertised in the newspaper that the true owner can take the watch after showing proper evidence. After waiting for a certain period of time, when the true owner did not turn up, he gifted that wristwatch to his son Mahesh. A few days later, Madhav, the true owner of the watch, somehow noticed his watch on the wrist of Mahesh. He approached him to collect the same, but Mahesh refused. In the evening, Raghav called Madhav and told him that he has incurred 20,000 to find the true owner. If he fails to reimburse him the lawful charges incurred, he will sue him for the recovery thereof. Yes. Or retain the possession of the watch with him until recovery. Even he can sell the watch for the recovery of expenses. So, 4 things are being talked about: gifting the watch, lawful charges. For this lawful charges, he wants to sue him, he wants to exercise lien. And the 5th one, sell the car. We have to mention all of this. Whenever you read, this is how you should identify the provision in the question. Ki either this is happening. So, again, as per the provisions of whatever, when a person finds goods belonging to another, he must trace the owner and return the goods. The finder gets into the position of a bailee and shall have the following rights and duties. We don't have to write all of it, only the relevant one. Right? Only the relevant one. First, so I'll first write duties. The finder must trace the true owner of the goods and return the goods back to him. The finder must not appropriate the goods. Must not appropriate the goods. ठीक है. This is duties, rights. First, right to sue. The finder shall not have any right to sue the owner for any lawful charges incurred by him as they have been incurred voluntarily. Second, right of lien. The finder shall have a right to retain the goods for the expenses incurred. Third, right to resell. The finder shall have a right to resell the goods if the finder is found but he refuses to give the lawful charges and the lawful charges are 2/3 or more of the value of the goods. I really admire the fact that you will be writing for 3 hours continuous. My hands, in just not even an hour, and my hands are already gone. So, therefore, gifting the wristwatch to his son. Therefore, first, gifting the watch to his son was not lawful as he has no right to appropriate the goods, right? Second, warning Madhav to sue for incurred in finding the goods. Warning him to sue is not lawful as he had incurred the expenses voluntarily and has no right to sue for them. Third, retaining the possession till recovery. He can retain the wristwatch till the recovery of expenses as he has a right of retainer over the goods for expenses incurred. So it is lawful. So it is lawful. Fourth, what is the fourth question? See, selling of wristwatch. What do you think, guys? He can sell the wristwatch. Selling of wristwatch is unlawful as the price of watch is 1 lakh and expenses incurred is 20,000, which is not 2/3 or more. It's not 3/4 expenses. It's 2/3 or more of the value of the goods. Clear, all of you? Yes, with this we are done with this question. I hope it's clear. You have to, this is how you should identify the question. Chalo, the next one. Tell me. This question. Read it and please tell me. Guys, tell me what provisions will come for this. So for this question, one of my students, she had written, good evening, Pranav. She had written the answer and she scored a 6 out of a 7. I'll just tell you what all. Yes, you will write that. Yes, if it's a 7 marks question, because the provision is not that much. Chetra, correct. You should write all of that. That will help you fetch more marks. That will help you fetch more marks. Okay. So, R owns an electronics store. P visited the store to buy water purifier. He specifically requested R for a purifier with a copper filter. As P wanted to buy the purifier on credit with the intention of paying in 9 equal monthly installments, R demands a guarantor for the transactions. S came forward and gave the guarantee for payment. R sold P a water purifier of a specific brand. P made 4 monthly installments and after that became insolvent. Explain the liability of S. So they are actually asking you about the liability of surety. This is the question. First, yes. What would be your answer if R sold the purifier misrepresenting it? So this is based on misrepresentation. So these are the two provisions. But since it's a 7 marks and in the special contracts you will see most of the provisions are just 1 or 2 lines and it's a 7 marks question. So this is something which is very, very subjective, which you have to decide at that given point of time. Okay? It's a very, very subjective thing and you have to decide. Thank you so much. At that given point of time, how much should be the content of your answer? So if you see it's a 7 marks, then you have to give a little more content. So then you should explain what's a contract of guarantee and all. So see here, obviously as per the provisions of whatever. Yes. A contract of guarantee is a contract whereby one party presentation of answer will fetch you good marks, because the cleaner you present, it's very good for you. It's very evident for the examiner. Promises to pay on behalf of another or promises to perform on behalf of another in case he fails to do so. The person who makes the promise is called the surety. The person on whose behalf the promise is made is called the, I'm so sorry, principal debtor, rightful. The person to whom the promise is made is called the creditor. Right? This is the definition. Now, we have two provisions here. One is the liability case and one is the other case. In case of guarantee, the liability of surety is, let's give me 1 minute. I'll just finish this tea. Okay, I don't want to let it get cold. Sorry guys, tea is life and nothing before tea. Chalo, in case of guarantee, the liability of the surety is coextensive to the liability of the principal debtor. In case the principal debtor fails to pay, the surety is liable to pay on his behalf. Then, if the guarantee is obtained by the creditor, by concealment of material fact or misrepresentation of material fact, the contract becomes voidable. In such a case, the surety is not liable. Okay? We are done. Second paragraph we don't need. Therefore, first question explain with reference to what is the liability of the surety to pay the balance. Therefore, is liable to pay the balance installment on failure of the principal debtor to pay. Now, one thing that I want to explain here is if the questions have multiple, like now, what would be your answer when they say like this? Then you should write in case. You will explain the case. How? What would be your answer if R sold the purifier? In case R sold the purifier misrepresenting, you will write the whole case. Okay? The contract becomes voidable. So, the surety is not liable to pay. I did not understand. What did you just ask? Ma'am, should we not write the second part itself? As in? I did not understand. What did you mean by that second part itself? As in? Chalo guys, I want you to read the next question, padho, or identify what should be written. No, we will always give a conclusion, no? Second paragraph is just a summary of the case, no? So conclusion, therefore, R is liable, that you have to write. That one line has to be there, no? Therefore, R is liable, that one line has to be there. Please read the next question. Tell me what all provisions will come. Let's see how many of you can identify. Contract of bailment is fine, Shailesh, but you have to give me the provisions that will come here. Contract of bailment, ठीक है, but contract of bailment is which provision of contract of bailment? That is what I want you to tell me. चलो guys, quickly आंसर बताओ, जल्दी से बताओ, जल्दी से, a little fast. Actually, see, I have in that video that I was telling you I'll upload, I have talked about this. You're supposed to write the 3 paragraphs, but let's say first, please, first few answers write the 3 paragraphs. But if later you don't have time, you can just skip the second part and you can just explain the case in the conclusion. Only you write giving the reason. That's it. Just write the conclusion giving the reason. That's it. But yes, otherwise, yes, you should write. That is how you should write. The rest of you, no one is answering. No, sadly, I'm not a CA. Sir, you cannot, you have to tell me all the details of the provisions. X was running a business of car on lease. Lease, okay? One fine day, Y came to hire a car. One more thing, remember, if it is a non-gratuitous bailment, please remember it cannot be terminated. It cannot be terminated at, yeah. Please always remember, non-gratuitous bailment cannot be terminated at any point of time. You can only terminate it when the purpose is done, or if it is for a time is done, whatever. Okay? Remember that in case. Right? In case. Okay? I want everyone's attention here. X was running a business of car on lease. One fine day, Y came to hire a car for 10 days for his business tour from Delhi to Amritsar. X offered him a Honda City for 50,000. This is the higher charges for 10 days. On a condition that petrol and toll expenses will be borne by him. So we know in case of a non-gratuitous bailment, the ordinary expenses are always borne by the bailee. But if there is any extraordinary expenses, those are borne by the bailer, right? During the journey, engine of the car was choked. Y had to spend 10,000 for repair of engine. So extraordinary expense. So we have to write about the expenses. So this is one is about what? Expenses. When he was coming back from Amritsar, brakes of the car were not working and a major accident of Y happened due to this. Y was admitted to the hospital and paid a bill of 50,000 on recovery. Right? So this is what? This is loss due to fault in goods. Y asked X to compensate him charges for the car repair and hospital expenses amounting to 60,000. Guys, can he claim it? Ye batao, can he claim it? X denied for the compensation, that saying that he was not aware about the engine and brakes fault. Y filed a suit against X for the recovery of the damages. Okay, I want whether he can claim the 60,000. That's my question now. Whether Y can withhold the amount of higher charges, whether X is liable to pay damages as he was not aware of the fact of the fault. He says, I was not aware of the fault. He's saying that he was not aware of the fault in the goods. So, this is damages due to fault in goods. So, these are the two provisions. One is expenses, one is fault in the goods, right? These are the two provisions. Yes. So, these are the two provisions that you are supposed to write. But because the question is, let's say if it is for 7 marks, Shouldn't you write what is a bailment? Yes. So you should write a bailment is the transfer of possession of the goods, whatever. The bailer shall have the following duties in case of bailment. 1. Duty to disclose faults in the goods. It is the duty of the bailer to disclose all faults in the goods. If the bailment is a non-gratuitous bailment, the bailer must disclose all faults in the goods, whether known to him or not. If the bailer fails to disclose the faults and the bailee suffers damages, he can claim the damages from the bailer. Correct? This is the first one. Second, duty to pay expenses. In case of a non-gratuitous bailment, the ordinary expenses are generally borne by the seller, by the bailee, but the extraordinary expenses are borne by the bailer. Okay? In case the bailee does not get his damages or expenses incurred, he can retain the goods or the charges payable under bailment. Right? With this we are done with the provision. So whether why, so see, please, here question is 1, 2, no. So when you are writing here, this 1, 2 is okay, but don't write 1, 2 like this, because the examiner will get confused whether you are writing the conclusion or whether you are writing the provision. Okay? Now coming back, whether Y can withhold the amount of higher charges. Yes. Therefore, Y can withhold the higher charges. I have forgotten to write double H, it should be double H. Second, whether X is liable to, as the bailment was non-gratuitous, the bailer is liable for all the faults whether known to him or not, right? Okay, with this we are done, and we are done with one last question we are left. I want, if you tell me to write this also, I will write. If you feel not needed, we will just discuss it. But there is one thing in this answer that I want to show you. Quickly read the answer question and tell me what should you write. Guys, quickly. Okay. Okay, what else? Guys, I'm waiting for an answer from all of you. I want an answer from all of you. I want to tell you also what the ICI had actually given in the, what you say, what they have given examiners comments have come. I want to tell you about this answer. They have given an examiner's comment. I want to tell you about that also. Okay. Okay. Okay, so let me just discuss this question. ABC Infrastructure Limited was running business successfully from several years. P was the purchase manager of the company. He authorized his agent Q to buy raw material on his behalf for construction of roads in Delhi. He instructed Q to buy only Majboot brand cement at 2,500 per ton to maintain the quality. However, Q bought 1,000 tons of Majboot brand at rupees 3,500 per ton. Q has not disclosed the fact to R that he was buying cement for when P discovered this. He refused to pay R and rejects the cement bought by Q on the ground that Q has exceeded his authority. R suffered a huge loss on account of this. Okay, before I tell you what answer has to be written, I want to read out the examiner's comment. Okay, I want to read out the examiner's comment on this. What was his opinion? I want everyone to listen very carefully. The examiner's comment was, Most examinees responded to the question on the principal's liability when an agent exceeds their authority and fails to disclose the principal's name in a generalized way rather than as per section 227 and 228. That means what? What they are hoping from you. Now, just as you told me, exceeded authority, not liable. But if you remember, in exceeded authority, we had discussed three situations. First, if he exceeded authority, not liable, that you should write. If the contract is separable, then the from the if the contract is separable, that is the authorized part and the unauthorized part is separable, the principal is liable for the authorized part, but the principal is not liable for the unauthorized part. Second, if the contract is not separable, then the principal is not liable for the whole contract. Third part, where, because it's a 7 marks question, no, you cannot just write one line. What the students did, they just wrote one line that if he exceeds his authority, not liable. What ICI is expecting you to write is, they want you to write first, if it exceeds the authority, not liable. If the contract is separable, that is the authorized and the unauthorized part is separable, they are liable for the authorized part but not liable for the unauthorized part. If they are not separable, the principal is not liable for the whole contract. If the principal has let the third party believe that the agent has the authority to do a particular work, then in that case, the principal is liable even if the act is outside the authority. Then, where the agent makes a contract in his own name without disclosing that he is a principal, then there is a presumption that he himself shall be liable for that contract. That is, there is a presumption that he undertakes to be liable personally. So these are the things that you should write in the answer. So please understand, even if you give the answer without writing the whole provision properly, you will not get good marks. So they are expecting you to write all of this. Do you want me to write the answer, or this discussion is okay? I can write it. Anyway, we have written so many, doesn't make a difference. I'll write the main paragraph. You want me to write, or this is okay? Shailesh, I don't understand the yes. Ajay, you mean to write? Okay. For the acts of an agent, okay, yeah. For the acts of an agent, the principal is liable. If an agent does any act which is outside his authority, and such act can be separated from the authorized act, the principal is liable for the authorized act but not for the unauthorized act, right? And then, if the act cannot be separated, if the authorized and unauthorized part cannot be separated, the principal shall not be liable for the acts of the agent, right? When the agent exceeds the authority and misleads the third party to believe, and principal misleads the third party to believe that the agent has authority to do the work, the principal is liable. If the agent exceeds authority and misleads the third party to believe that he has the authority to do the work, the agent shall be, guys, even if you don't write this, it works, okay? Sorry, this paragraph, if you don't write, it works. This is important. He shall be personally liable to the third party for the work done. This is for exceeds the authority. This is all what, so the institute is expecting you to write all of this. If you just write one line, principal is not liable, not enough, khatam. Remember, we have done this when we were doing, liability to the third party or liability of the principal. We had done this. Now, when the agent does not disclose the name of the principal, then there arises a presumption that he himself undertakes to be personally liable. He did not say no, he is acting for the agent, for the principal. That means we work under the presumption that he is personally liable. So this is your provision, guys. I hope it's clear. So here, whether P is bound. Yes, why not? You should underline the keywords. The examiner will be impressed that this guy knows what he's writing. You should underline the keywords. Therefore, whether P is bound. No, P is not bound. But can I also write that the third party can recover the money from the agent? Can I write that? Can I write the third party can recover the money from the agent? Yes. On the other hand, Q refused to liable in this situation, whether R can file a suit against Q. Yes. When he contracts in his own name, he works on the presumption that he will be personally liable. So yes, we can sue him. Is it clear to everyone? So with this, we are done. I hope it's clear to all of you, and I hope it helped you also in this session. Please be careful about what you are writing in the exam. Make sure your answer has whatever it needs, because if it's a 7 marks question, you writing 2 lines will not fetch you marks. I don't know if I'll be doing more live sessions or not. I'm not very sure. If I do, I'll see you again. If not, all the best, guys. And for the next 4-5 days, if you have any doubts, anytime you drop a message, I will be available. Okay? So can I end the session here, guys? So all the best guys. ठीक है? So I will see you. Bye bye, bye bye, bye bye. Thank you. Bye bye, bye bye. I'll see you all again very soon, hopefully. Till then, keep studying अच्छे से. Bye bye, bye bye, bye. And keep practicing. And please don't be disheartened. Don't panic right now. Don't panic. Most welcome, Chaitra. Chalo, bye bye, bye guys. Bye bye, bye. Thank you guys. Thank you. Bye bye, bye. I'm just ending the session here. Okay?